just want to thank all of our audience members who are tuning in today. I also want to thank our guest speakers, Carrie Heinzl, Shmuel Stern, and Bill Rogers, who I'll take a moment to introduce in just a few minutes. And I just want to mention we're very appreciative of all of you joining us today for the discussion on divorce and financial disclosure. We have a great turnout today and also a great lineup of topics that our speakers will be covering over the next hour or so. So some of the topics that will be covered throughout the presentation are the rules and full disclosure, storage folders and naming documents, proactive disclosure, financial neutrals, forms 13.1 and 13A. They'll also be discussing the merry-go-round of financial disclosure, affidavit of documents, experts in hot tubbing, the nasty of disclosure, and some tips and tricks as well. As always, our panelists will be answering audience questions throughout the presentation, and we'll also leave some time towards the end of the webinar as a dedicated Q&A segment. So before I get into our panelist introductions, we'd like to get to know all of you a bit better and understand who's in our audience today. So as I go through, if you want to take a moment to answer our first poll question, tell us a little bit about yourself. I appreciate it.
I want to thank Shannon for being here and hosting, as always. So we're going to give everybody a couple minutes. I'm going to ask an audience question that came in, but just before we started, we're talking about Bill's ban, sole custody, updating it with the rule changes. What was it, parenting time, Bill?
Sole decision-making responsibility. That was what the ban is called now.
If you have a family law related potential ban name for Bill's ban, please put it in the chat. Shannon?
Through the Q&A. So our
Through
chat.
The Q&A.
Yeah.
Drop it in there. We'll read them out as today's program goes, but let's get to some questions. So this is interesting. Shmuel, maybe you can help us with this one. Should you provide a disclosure if you already have an agreement, but the other party is disputing the legality of the agreement? I guess they're saying, can I rely on my agreement and say I'm not giving you anything?
Oh, that's a good question. That's like jumping into the deep end, right?
Right. I'm starting off. We're going to give you and Bill all the hard questions, and Carrie and I are going to take the easy ones. How's that sound?
I love this.
Okay, so the short answer is that people have fought over this question, so there is case law on it, which is helpful for us so that we don't have to invent the wheel. From my recollection of the case law, and this is related also to the question of do we go, if you're going to bring a claim to set aside an agreement, let's say it's a marriage contract or it's a separation agreement, do we just take the whole case to trial, which might take some time, like years to get to, or do we bifurcate and cut that issue off at the beginning, have that issue resolved, and then continue the trial? So those two issues are actually very much related. And the short answer, I think, would be, yes, you do have to provide disclosure if it's related to that question. So in other words, if you're claiming that you need to determine whether there was sufficient disclosure provided at the time of the agreement to make the agreement, then certainly the court's going to order that disclosure to be provided at first instance, and then the other stuff can wait. That's the short answer.
Sounds like a messy piece of litigation. So, Bill, we did get an answer come in for your ban. Can't fix crazy. I wonder if they know you personally. I don't know. Let's see what our poll results are. All right, family lawyer, half our audience. We had 400 people register for over 400 for today's program. So thank you everybody for signing up. Lawyer from another area, 14%, financial professional, 18%, law clerk, 18%, other professional, 14%, and dwindles off from there. And other, you can put that in the chat or the Q&A. All right, so Shannon, I think we've got one more quick poll question and we're going to get at it.
I'm going to take a moment to introduce our speakers and then we'll get into our next question.
Okay, I'm getting too excited. I love the polls, but I get to hear what the audience is
Everyone
thinking.
needs to know who's here today.
Okay, I'll be quiet.
Give them the introduction they deserve. So,
Shannon, please don't give me the introduction I deserve.
Please, Shannon.
Give me a
please
nice
do it.
introduction.
Yes, everyone but you, Bill. First of all, I want to start off by introducing Carrie Heinzl. Thanks so much for being here today, Carrie. Carrie is the founder of Fairmore Family Law Financial Solutions. Fairmore offers independent fact-based financial analytics and settlement insights to individuals and couples working through separation and divorce. Carrie is an active collaborative process trainer, co-teaching the introductory program for new collaborative professionals and advanced level trainings for seasoned practitioners. She sits on the board of directors for York and Durham Collaborative Practice and is the president-elect of the OACP, or president now, I believe. Sorry,
I'm president now.
that's been updated. Carrie has taught statistics, research methodologies, and psychology at college and university levels. In addition, Carrie has presented at conferences for the OACP, Family Dispute Resolution, and Institute of Ontario Annual Conference, and International Academy of Collaborative Professionals. Very impressive, Carrie.
Oh, thanks.
Next we have Shmuel Stern. Thanks for being here as well, Shmuel. Shmuel practices exclusively in family law in Ontario since 2003 and Ohio since 2021. He is the founder of Disclosure Clinic, a limited scope practice to identify and cogently present family law financial disclosure. He is a past chair of the Ontario Bar Association Child and Youth Law section. He is the website editor for courtnoticefinder.ca, a project organizing extensive and changing family law related court notices issued by Ontario courts since COVID-19. You can follow his Ontario family law case law on his Twitter feed at Corollary Relief. Thank you so much, Shmuel.
You
Next,
pronounced it
Bill.
correctly.
Sorry?
You pronounced it correctly. It's corollary.
Okay, great. You could tell my hesitation. I'm glad I got it right.
It's not corollary.
No.
I've been saying it wrong for 15 years. Shmuel.
21.
Now you know, Bill. All right, on to Bill Rogers, who is our managing associate lawyer at our firm, also our resident comedian. His courtroom experience includes numerous motions, several full-blown trials, and he has also had the privilege of winning a major family law victory at the Ontario Court of Appeal in 2014 with McConnell versus Huxtable, which prevented the imposition of a proposed 2-year deadline on property claims by common law spouses. And when he's not practicing law, he loves spending time playing music with his band Sole Decision-Making Responsibility,
Yes,
although we're taking new names. So
it used to be sole custody and it's SOUL.
yes.
That's the cool thing.
Bill, we did get sorry to interrupt, Shannon, another suggested name, Souls of Custody.
Nice.
So keep the suggestions coming in. We're going to come up with one today.
I like it.
Right. And last but not least, we have Russell, who is the founder and senior partner at our firm. With over 25 years of experience, he uses his knowledge and expertise to serve his clients in all aspects of family law and helps them in coping with the difficulties of separation and divorce. He uses his experience to create unique solutions for each client to enable them and their families to move forward and support them through this transition. Russell has written 4 books on separation and divorce and is a fully trained collaborative practice lawyer. He also speaks at conferences on collaborative practice, marketing, technology, and the law. So I will now pass things over to you, Russ.
All right, with your permission, Shannon, could we run another poll?
Yes, you may. Thank you for asking. It's time for the next poll.
And we're going to go to another audience question because we've got a couple in advance. Keep putting them in. We love getting the questions from the audience. And let's see if I can find what the question is. Do you remember the question that we're going to ask you, Carrie?
I think I do. I think you were going to ask me about what steps can be taken if somebody doesn't want to do disclosure.
Yeah, audience member sent that in. What steps could be taken? This poll is, what am I obligated to disclose? So let's see what our audience thinks. While we're waiting for the audience to answer, what steps are open to you?
You know, I think this is going to depend on the process that you're in. So no matter what process you are in, you are obligated to provide disclosure. If you are in the collaborative process, which is an area that I like to practice in mainly because we can stay out of the courts, we're going to take different steps. So you're going to use maybe a financial professional. We're going to help you gather that information. If you're not giving it to us, we're going to talk to your legal counsel, we're going to get the full team involved, or finding out why we can't get something. One of the things with collaborative is it's the why. We really want to nail that down. If you're in the court system and you're going through that one and you're refusing, this is going to get a little bit messier for you. It could be that you're ending up with a court order. The judge is saying you don't have a choice. You may end up with costs against you. If you want to keep your costs down low, my advice to everybody is provide your disclosure as it's asked for, when it's asked for, and don't play the games. It's never a good idea.
All right, good tips. Let's see
I
what.
hope.
Go ahead.
No, I'm trying to keep them short because I know we have so much packed in for today.
Let's see our poll results. Actually, a colleague emailed me the other day and said, this is a pretty ambitious agenda. I go, yeah, it is. We're going an hour and 15. We got an extended period and some Q&A. So, all right. So what am I obligated to provide? Everything. Pretty sophisticated audience. Only what the other lawyer asked for. Well, that's an interesting approach. If they don't ask for it, then maybe you're okay. Only what the court orders. Whatever I feel like. I've got clients who tell me that all the time. Other, so you can put your other answer in. So thank you for participating in that poll. So we're going to talk about the rules and full disclosure in a moment. I just want to share my experience when I'm in the Central East region. Generally, family court judges in the Unified Family Court are of the view that full disclosure is the rule all the time. And they don't really deviate from that. I did have one case. I'll tell a story a little bit later. When we did deviate, there was a national security issue, and there wasn't full disclosure in that particular case. So when we have a case conference, we'll conference the issues, including disclosure requests. Usually, what the judges I appear before order counsel to exchange the request within 30 days. Any disputes are resolved by way of 14B motion to the case management judge. Usually it'll carry a cost consequence if somebody's being unreasonable. That resolves most disclosure issues fairly quickly. There's some issues involving third parties, which might get a little bit more complicated, but that's the general approach I'm seeing. How about you, Bill? Has that been your experience?
Yes, it has. I mean, my approach is generally, I've got nothing to hide. So you can have whatever you want, and unless it's really hard to get, that can be a problem. Or if it's sort of a vexatious, time-wasting sort of thing. Generally, my approach is, you want it, you got it.
Yeah. And Shmuel, what's your view? And then let's get into the rules and full disclosure. You can give us
I know it's a poll, so I'll take it for that, but I actually disagree with the results of the majority result that you disclose everything, because I'm not going to be disclosing, I don't know, my dirty underwear, right? I'm not disclosing everything, right? I am disclosing what's relevant in the law related to the legal issues in my particular circumstances. I know like it's a technical answer, but that's the correct answer. And then the question that then becomes, there may be tangential relevant disclosure that's going to be sought or asked for in addition to the basics, which I'll discuss in a minute, which we get into the issue of proportionality. And it's not 0, it's not 100, it's somewhere in between, and makes it very difficult to figure that out. Like I have plans in my head to try to come up with like different color levels of what is.
Just to jump in there, some counsel, as a matter of strategy, over disclose. Right, they'll give you, or here's 12 banker boxes, have at it, and they don't sort it or organize it, they just produce it. But
a rookie mistake, and I know we're kind of going ahead here, but a rookie mistake is to ask for a lot of disclosure in the hopes that the other side is not going to provide it, and then that's going to be part of the merry-go-round that we're going to discuss, right? However, what happens if they do provide it?
Then you got to read it.
And then you got to read it. And the other side's gonna say, listen, I make $1 million gross, but I'm negative $5,000 income, right? And I gave you everything you asked. Okay.
I had a case like that before Justice Roselle. The lawyer swapped me. We worked for 3 days, produced all the stuff. And then she was complaining before the judge that she had, 6 inches of disclosure she hadn't read to prepare for the case conference. And I said to the judge, they asked for it. And now she's complaining that she's got it. Like, it looked poorly on her that she made
I like to
the
say,
request.
careful what you ask for, you may just get it.
That's right.
Russ, I wonder if you can get an order for someone to stop disclosing. It's like, I can't
Too much
handle this.
information.
Yeah, it's tedious. Just stop.
All right. Well, let's actually get into our first topic, the rules and full disclosure. What do we need to know here?
Okay, so I could talk about the law, right? I think the just as a starting point before I actually tell you what I'm going to tell you is that the starting point always is the underlying law, the substantive law, such as the Family Law Act or the Divorce Act, that generates the issues that you're going to be talking about. Financial disclosures should not be an issue unto itself. It is supposed to be the information on which we can determine the substantive issues. Okay, so like, I know we talk a lot about disclosure, but just keep it in context that it's actually trying to get to an end result. It's not an end unto itself. Fine. Okay, what I thought about doing right now to help everybody is to explain why everybody's on this website, on this program, and to show the basics. Okay, and the analogy I came up with is as follows. Imagine you have a distant relative that passed away. It's very sad, and they lived away from Ontario, so let's put them in Manitoba. And you are elected to go out there to deal with all the funeral arrangements. So what do? You quickly go online to Air Canada, and you type in to grab a flight, and you book a flight, and you're saying, I'm not going to be there long. I'm going to book just for a carry-on. You then rush to the airport. You go through e-check-in. You go through the security. You get to the gate, and you're waiting in line, at the gate, and the attendant says to you, sorry, your bag does not fit into that metal frame that's over there in the corner. Everybody knows that metal frame, right? That's the limits of the bag dimensions. And you're standing there at the airport, ready to get on this airplane, and you're looking at the frame, you're looking at the agent, and the first question you have to ask yourself is, how does that frame help anybody? Like, I'm at the airport already, I packed already, I thought I was getting a carry-on, and now you're telling me that I have to pay another $75 to check it in. Like, why? Who's that frame helping? And ladies and gentlemen, that frame is our Form 801 automatic order. Okay, so if you get to court and you need a court order to tell you what to do about how to pack your bags, you've lost the plot already. And you have to ask yourself, who is this automatic order helping? Because you're already in the process. Now, sometimes that has to happen, when there's like emergency and you're urgent and you run to court. But most times you want to know everything before you get to court. Okay, so that's problem number one, which is people are learning the information through a court order if they even read it. So then you're back. Let's go back to the airport. You're standing there and you say to the agent, wait a second. I checked in online and I bought this online. Where's the information? Like, where's the information for the baggage dimensions? And so the agent says, oh yeah, it's on our website. Just go to the menu where it says get ready for travel. And then you scroll down into the middle of that page, and there is a reference on that page to another website that there's no link to that other website. But there's a reference to it, so you can just highlight it and put it into Google, and hopefully you'll find it. Okay, and you're like, that makes no sense. By the way, Air Canada is 2 clicks to find out. I tried it. Okay, but you want to see how we do this in family law? Okay, so first you have to know to go to the family law rules. So here's the family law rules. And the family law rules, if you go down to Rule 13, right? First it talks about which financial statement to use, but I'm scrolling down to 3.1, okay? So if you have a claim that relates to support, that's what it says over here, then you need to provide the income and financial information referred to section 21(1) of the child support guidelines. There is the other website with no link. Do you understand how disjointed this is? How is anybody off the street supposed to know what to do here? And we're talking, you know, in the questions before we even started about like advanced questions, but I'm not even there yet. I'm before court. I'm before the process starts. You're talking, you know, somebody who's recently separated needs to know what to do. Where is that information? So, and the answer is it's buried in the law, and we need to bring it up. So for support issues, we have to go to the child support guidelines. By the way, even if you don't have a child support issue, we're going to the child support guidelines for spousal support also for this issue. So that's confusing also. So you go to section 21, because that's what it said in Rule 19, and there's a list. Oh, there's a list. Okay, now most lawyers know the list, but I could tell you that most lawyers do not provide the tax returns when they file with courts. They will do the bare minimum to get the financial statement to be filed. They'll provide the pay stub and the 3 notice of assessment. Most people stop at the notice of assessment. But number A is the tax return. So I would encourage everybody to look at this list, and even experienced lawyers don't follow it, because I could tell you when it comes to corporations, it actually says you have to provide the financial statements for the corporation and subsidiaries. Okay, and I've never seen people provide at first instance subsidiary corporation financial statements. You have to learn about it before you even get there. So that is income, and then if you continue on at rule that's 13.3.1, and then you go continue to 13.3.3. Then there's a list here, which is for property claims, okay, specifically equalization of net family property claims, and it has a list here, and the list does not line up with the with the financial statement. It's not in order. I'm not sure why, but there is a list here. It's actually kind of helpful. I'll tell you where it's not helpful. You know, here it says you should provide an MPAC assessment for any real property in Ontario, right? It doesn't talk about foreign property. So look, it's like a little interesting quirks here. There is an additional clause here, like a catch-all called 3.4, which is you're supposed to be providing, and there are timelines here if you're in court, all the information if you're going to be making a property claim that is not equalization, such as an unjust enrichment or a resulting trust kind of claim beyond the scope of this program. So Rule 13, 3.1, 3.3, 3.4 is reflective of the disclosure that we're supposed to be providing for specific types of claims: child support, spousal support, equalization, and property claims that are not equalization. So that is the gist. And now you know why why we're always behind the 8 ball here. Is that the right terminology? Because it's buried and we need to kind of bring it up. So there you go.
And look at the child support guidelines, even if there's no child support, because there's rules there that you got to follow.
That's right.
Only lawyers would design a system like this, right? All right, so let's go to storage, folders, and naming documents. You've got a good system for this, Shmuel. What are you recommending?
Okay, so yeah, give me a second. Okay, the first thing you have to think about is that we never talk about storage to clients at first instance. We always say, here's a financial statement, fill it out. Think about that. And then the clients look at this form. It has lots of little boxes. And I could tell you, because I fill out other forms in life, you know, like a bank form or something like that. And there are boxes and you're always scared. If I put something wrong there, what's going to happen? So imagine, look at the 13.1 and multiply it, that feeling. And so it's very helpful to pause for a second before you hand or start a financial statement to say, okay, wait a second, what's the big picture here? And the big picture is 3 things really. It's information gathering, it's document collection, and then collation, like where we put it all together in a package. You were saying before, Bill, when like what good is information if it's impossible to navigate, right? So we don't want to be throwing information. Sometimes people want to throw information at the others to confuse them, right? But we want to be a little bit more compelling and say, we're taking this process seriously because we have claims that we want to be taken seriously. We have claims regarding the house, whether we want to sell it or we want to stay in it, and we have child support claims. I have a child support claim against me, and that's okay because I know that I have to pay child support, but I don't want to pay child support in the amount that you're saying I should pay child support. So, have that conversation, the big picture, and then say, what is the best way to collect documents before we even hand the financial statement? What is the best way to collect documents? And I'm very broad thinking. Some people don't have technological experience. Some people are very experienced. I prefer online storage because it's easy to share. And the takeaway is the court has no expectation of how you're supposed to. The law does not say how to share. So however you do it at like you mean it. Okay, so like pick your storage. I use Google. Other people use the Microsoft SharePoint or whatever it's called, and there's multiple ones, and just go through it. Number two, the document naming, same concept. There is no law that says how to name documents. In fact, I usually get deluged by documents that have no naming protocol. It just says scan 000, right?
Whatever the photocopier put on it, right?
Yeah, that's right.
And
And I'm cool
yeah.
with that. But the truth of the matter is I want to organize. I'm going to talk it from my perspective. Me as lawyer for client, I want to organize the documents so I can find the documents. Forget about the other side. Forget about court. I want to be able to find my own documents. So on my website, and I think Shannon just shared that link, I do have a guide to the financial statement, and I'm going to show you a specific page on it. So give me 10 seconds. So this is the guide. It's on my website, and it helps with identifying the documents you need. But regarding naming them, what I find, I just have to find it. Here we go. Let me see if I can just make this slightly bigger. Okay, I find actually, and this is something that I've given a lot of thought on, that the naming protocol for income documents is different than the naming protocol for property documents. So for income documents, generally speaking, I think I would want to start with the year. Okay, so even here, I'm not even following my own advice here. I just want you to know there's no correct. I've seen people start with income tax returns, so they all line up. Sometimes you got to think like a computer, like when you press sort by name, how do you want it to line up? And so I've been thinking about with income documents to start with the year. Okay, when it comes to property documents, what something that I found is helpful is to look at the financial statement, and you'll see that there are different columns. So you can do that. Checking is the category. The institution is RBC, the account number is 5576, and then the date of the document and the type of document. Okay, now I use this kind of naming protocol again to think like a computer. What I would like to show you is folders that my default folders that I use is exactly in line with the financial statement. So like, right, it's part 1, part 2, the part 3 doesn't usually have documents. Part 4, part 4B, like, so it goes in order, goes to the debts, which is part 5, part 6 is date of marriage, and even part 8 has disposed of property. So once you start naming the documents, you can actually start dumping them into folders. And I have to be I want to encourage people to not follow what I just showed you, right? I think you can also just do 4 folders: income, expenses, assets, debts. That's it. What I have found though is that when you tell clients make 4 folders and name them, they feel actually encouraged. They are moving along on a process just by making those 4 folders and naming them. They're like, oh, okay, we got someplace to put something. And then you can start talking about what to put in there and the naming protocol. And the last thing I would just say with the naming protocol is whatever you use, try just to be consistent about it. That's the most helpful advice.
All right, super helpful. Thank you. Shannon did put the link to that site in the chat. So if you want to go there and look at the forms, they're there. Proactive disclosure, Bill, what should we be thinking about?
Well, again, my strategy is I have nothing to hide. And sometimes clients don't like that, but I think Carrie would agree with me. If you try to hide stuff and it comes out later, you're gonna end up paying more. Right, Carrie?
Oh, that's pretty much a guarantee.
Yeah, you can't hide, especially if you're in court. It will come out. So, and just refusing a disclosure that you can get easily and it's not vexatious, it just sends the message you have something to hide, and you don't want that. And I'll never forget when I was just starting out back in the 1800s, I was in front of Justice Penny. I don't know if he's still on the bench. I think he is. We're talking about disclosure, and he looks at me and he goes, "Non-disclosure is the cancer of family law." And I'm like, why are you looking at me and saying that? Like, what did I do? And then I found out, no, he's quoting from a case called Luskin, Leskun, from 2006 Supreme Court, which in turn was actually quoting an earlier case from 94, which a very brief excerpt, if I may. Quote, "Non-disclosure of assets is the cancer of matrimonial property litigation. It discourages settlement or promotes settlements which are inadequate. It increases the time and expense of litigation and the prolonged stress of an unnecessary battle may lead weary and drained women," and I guess it could just be men as well nowadays, "simply to give up and walk away with only a share of the assets they know about, taking with them the bitter aftertaste of a reasonably based suspicion that justice was not done." So I was really glad that actually he was quoting case law, not just looking at me and saying I was cancer. And by the way, I was disclosing everything, just so you know, because I got nothing to hide. Right, Carrie?
Yeah, exactly.
Nothing to hide.
Nothing
So-
to hide, Bill.
Nothing to hide.
Let's go to our audience and see what they're thinking. It's been a while since we've done a poll. You can answer the poll question. You can put a name from Bill's band into the Q&A.
Don't listen to him.
However you want to respond. So poll 3, what strategies can lawyers use to help their clients produce required disclosure? And just on a note, just with respect to proactive disclosure, let's just say we have a client who traditionally has a lot of cash coming in. We can think of a million examples of trades, people cutting wood on the side of the road, small business owners doing cash deals. We know the spouse is going to raise this. Would you recommend, Bill, just try to quantify that cash and build it into the financial statement with the gross up at the front end? And you can tell the judge at that point, yeah, we know there's cash and we've accounted for it in our financial statement. They may not agree with those numbers, but it adds a lot of credibility to your document.
I would 100%, Russ.
Yeah. All right.
The clients don't like it. You have to tell them this is the better way.
Yeah. And Shmuel, I guess you do the same, right?
I mean, I have the discussion with them. If you look at the the form 13 and 13.1, right above where it says income, like the chart, sorry, the income chart, which is usually on page, the bottom of page 2 or top of page 3, it actually says, please disclose, or please disclose all income, whether taxable or not. So it actually asks that question. It's very difficult. What I like to say is that people have been screwing CRA longer than they've been screwing their spouses in separation. And so the fact that they have non-reported income is not news. right? Like that's not what I usually what I usually tell the clients is who are you fooling here? Like this other person lived with you. And he probably right? Like so
No.
let's have that conversation. Like they if they know, how are we going to proactively deal with this issue? But it is difficult to get people who don't tell CRA about cash income to put in a sworn document because everybody's scared that somebody's gonna tattle on them to CRA. I've never seen it in my career, although everybody fears that.
Shmuel, can I just jump in real quick on
Yeah.
that? There's lots of clients who want to report their ex to the CRA. And I always say, don't do that. It will not help. It will just make things worse.
Yeah.
Always.
And when
Do you
when
agree?
clients aren't legally trained, when they look at that financial statement and that question, they're not thinking about the cash they got in the envelope from, their neighbor for doing that project. They just don't consider that income, right? They consider it something else. So it's our job to explain that to them. But really good strategy. Thank you, Bill and Shmuel. So let's see what our poll results are and see what our audience is thinking. So divorce and financial disclosures, strategies that can be employed, directions to third parties, 4%, neutrals, 8%, working with the clerks, give them bad news up front, overwhelming, all of the above. So I think our audience is certainly tuned in and getting this. But financial neutral, Carrie, what's the financial neutral? Well, why should lawyers or their clients care? I know why I care, but what do we need to know? What is the financial neutral and how can you help?
A financial neutral is basically somebody that doesn't have a dog in the hunt, and that we don't care about what the result is going to be. Basically, we are completely neutral. We're doing an agreed statement of fact. So instead of having two lawyers arguing over, no, the house is valued at 1.2 million, no, it's valued at 1.3 million, we're going to get an agreed value that everybody's coming together on. It makes things a little bit easier for families. It keeps things all in one place. Majority of the time, your financial neutral is working for both parties at the same time. We've done it where we're working obviously in the collaborative process, mediation process, but I've also had judges say, you two are going off to see Carrie Fairmore, and she's going to do your financial disclosure and she's going to do your finances for you because you guys are arguing and you're not coming together. One of the beautiful things about using a financial neutral is it can actually help regain trust within that relationship. So many times, I know you guys have all heard this, that, there's a buried chest of money in the backyard somewhere. There's a secret money tree somewhere that nobody seems to be able to find.
Envelope of cash under the bed.
Yeah, all of those sorts of things. We're able to kind of rebuild that where they're saying, I know they have this. And so you start going through the information with them. They go, oh yeah, that was the account. I'm surprised they disclosed that. And it's like, well, they did. Isn't that great? Isn't that a wonderful thing? We got that information from them. One of the things I was going to say about, cash, we do things a little bit different in our office. When we're dealing with both parties, I don't meet with them together. I want the parties to always be talking very openly and very honestly. I want to know what they think of their financial situation individually and as the family as a whole. But I also want to know what they think their former partner thinks about their financials. I want them to tell me, well, what do you think your partner is going to say about the value of this or what they're going through? And when we're talking about cash, it's really amazing to me. They're always pretty close when they're not talking together. And I find that when we get into group meetings, all of a sudden it's, no, the stack was this big. No, the stack is this big. No, the stack is this big. But when they're separate and they're telling me, they're going, yeah, he probably brings in about 15,000 on the side. And he's going, yeah, I bring about 15,000 on the side. I'm like, going, great. We've got an agreement there. You both told me the same thing. And when you're using a financial neutral, the other thing that they're going to do is they're going to be looking for things that are your goals and interests. What are your financial goals at the end of this? If your goal is to keep the house and you don't know how to do it, we're going to help option generate. We're going to do things that are going to say, hey, maybe we can get you there doing it this way. We're going to look at all of those things. We're going to help you fill out your forms, do your pension documents, all of those sorts of things. We're going to help you any way we can. You can't get your disclosure. We're going to help you find a way to get it.
Yeah, disclosure really production, that's what gets this merry-go-round spinning, right? So if you think about the traditional law firm, the lawyer, their law clerk's gonna produce a disclosure brief. They're gonna exchange it with the other lawyer. They'll do their own. They're gonna both be suspicious of what's being produced and ask for more. So requests go back and forth, and finally you end up in motions court arguing a disclosure motion. This is the merry-go-round that judges talk about. We're spending time and resources chasing down documents. Somebody like Carrie, what we do, it's not in everybody's business model, but it makes sense for our clients. We use one person to produce a brief for both counsel. So we're not producing two briefs. They meet with the client separately. They provide credibility to the data because it's not coming from an advocate, it's coming from a third-party professional. And it reduced costs. We're not producing two sets of briefs. We're not spending $5,000 in motions court. We're getting off the merry-go-round. If you have a client who's got a car dealership with cash and business expenses going through that, Carrie can go through the ledger one by one, add and say, yes, this needs to be added back. And it gives credibility to the data coming in. So super helpful.
I also like to call us a bit of the Grim Reaper, because we're always giving Sally something they don't want to hear.
Yep.
Oh, you're on that person's side. I'm paying way too much. Oh, they're paying me not enough. I'm guaranteed your financial neutral is always going to take the brunt of the Grim Reaper role in any process. And it actually can help legal counsel in a lot of ways, because now legal counsel is going, they said it's this, and you're like, but these are your documents. This is the fact. It can also like really help with the lawyer relationship with their clients.
Yeah, and
Especially
lawyers objected because their fear of the unknown is contrary to their business model. Then maybe the neutral is going to make a mistake, and those are common objections. But when you work with the neutral, you get through it fairly quickly. So let's move on to forms 13.1 and 13A. Lots of questions coming in on these two forms. I'm going to ask Carrie to take the lead on this, and then Shmuel, you're going to come in and help us understand these forms.
Yeah, really the forms are based on your claim. So 13.1 is going to be if you're looking at a property and support claim, we're going to get all that information. We really want to know what's happening. We're going to use that as the basis for what's going to be moved over into what's called a net family property statement. That net family property statement is going to be our comparative of what parent or what client one has versus what client two has. That net family property at the end of the day is what we're going to look at and say, what is the growth of your wealth during the timeline of your marriage? So what did you come into the marriage with? What did you leave the marriage with? What we want to know what the difference is, what happened during that growth. And then, so if client A has $100 and client B has $50, there's a $50 difference. The one that has more is going to pay $25 to the other one. You've equalized your property. That's really the most simplistic way of saying that. But we want to do that. If you're just going after a support claim, you're just going to do a form 13. You're not going to do the for everything, because there's not going to be a property claim in there. So, and that's more common later on, not so much if you're just starting out, you're probably going to start out with a 13.1, depending on where you're at.
Carrie, can I just jump in real quick and make
You bet.
Okay. The 13.1 is normally used for married people because married people get equalization.
True.
However, even with unmarried people, a lot of lawyers will still do what they call a mock-up, and they'll use a 13.1 just to get a sense of what the growth in wealth of each party was during the relationship, because that could come into play if there's a trust claim, like a joint family venture. It's I think of as common law equalization, but much more difficult to do. But a lot of lawyers are doing that these days. Not a bad idea.
Yeah.
Yeah. It'll help you understand whether it's worth pursuing the claim, right?
Yeah, that's
if they're upside down and have more debt, you're not going to make a joint family venture claim.
Yeah,
but
exactly.
If there's $1 million on the table, you might pursue it.
Absolutely.
Yeah.
Shmuel, 13.1, 13A, what do we need to know?
You don't want me to get started on what Bill was just discussing. I will just say the following, Bill, it's actually
It started, we're here, we're talking about it.
fine.
You have to say it now.
I'm going to say something substantive and something procedural about it. Okay, something so substantively, you know, the Supreme Court case on joint family venture for cohabiting non-married parties. There's Karen Baranow, but there was actually another case with it called Finesse. And I read it. Actually read the Supreme Court cases.
You read it? Are you having problems sleeping at night or what?
Yeah, seriously.
Finesse is actually the better one, I think. It's part of the same
yeah,
case.
but what happened in Vanessa is very interesting because what the court said was it was like a 11 or 13-year relationship total, and the joint family venture was only a portion of it. So intrinsically speaking, if you fill out a form 13.1 as if they were married, saying start a relationship, end a relationship, that's not even what the law says to do.
Okay, Shmuel, fine. Thanks for taking the wind out of my sails.
Listen,
right.
It's important because these claims are thrown around all the time, right? Procedurally, and dare I say stupidly, if you look
I'm in the room here.
Okay, good. If you look at Rule 13, 3.1, Rule 1 point something, like right at the beginning of Rule 13, dealing with financial statements, it says use a Form 13.1 for property claims. And then if you scroll up to the definitions, property claims, there are 3 under it. A property claim is Part 1 of Family Law Act, you know, equalization, which we would expect. And then B and C deal with unjust enrichment and resulting trust. So you have to anyway, like the rules say used 13.1, and that which doesn't make sense in law because I just discussed that. Rule 1.9, like also everybody talks about 1.8, but Rule 1.9 talks about, or 9.1 talks about adjusting the forms. Like you can adjust the forms, and so like I'd say date of cohabitation instead of date of marriage, but it raises a slew of issues of what's excluded property. Excluded property is not a cohabiting. Like how do we figure that out, right? Like so we're shoehorning stuff into a form. There really should be a 13.2 of a sort to deal with non-married claims. So
let's make another form. Right?
Yeah, we love forms, right?
But if you are successful on a joint family venture claim, the judge may direct you, say, okay, I'm finding that this relationship started on this date and ended on this, and then you can customize the form based on the direction of the judge if you have the data for those dates.
Right.
Yeah.
So let me just say something about the 13A, which kind of links back in how to help your client. You know, the 13A is supposed to list all the documents you've provided, and then now it asks you for the date that you provided it. But it's actually a deficient form, and I'm really working on this as a project to make a better 13A, because really what we should be doing is listing everything that's in the financial statement and saying, have I provided a document for it? And there should be another question, which is helpful for the client. If I don't have the document today, when can I get it? Right? Why don't we tell that to the other party? I don't have this, but I will be getting it X, because
shouldn't you first ask, is the document requested or required? Maybe the parties agree on the number.
Yeah, but sometimes what's happened is they've gone and they've ordered it from the CRA or they've ordered it from their bank, and the bank is telling them, listen, it's going to take us a month to get this because we've got to do it that way. So I agree with what Shmuel's saying, is that I think you need to be able to say, hey, I've ordered the document and it's on its way, so that people don't think you're just ignoring the request and somehow you're deficient.
Maybe I'm just too optimistic that people are going to agree. But
well, we're not asking the right questions, so we wait for people to ask them, and that is what takes away the trust.
Yeah, exactly. All right, so let's, you know what, it's been a while. Let's talk to our audience. Let's find out if
I love a good poll.
They're still working on Bill's ban questions, or if they've moved on. We've got some great questions coming in, by the way. Thank you. Keep them coming in. We're going to try to save lots of time at the end for Q&A. Next poll question. What are the most common objections to producing disclosure? You've got a list there. Let's go to an audience question. Let's see, what do we want to ask next? All right, how about this one? If spouses agree to backdate the separation agreement, will the court look into that? Shmuel, can they agree to change the date on the agreement?
The
Do they want the
mind,
date of the agreement or data separation?
Well, it says separation agreement, but maybe they mean the data.
let's address both, okay? Backdating any document is not a good idea, okay? And the reason why it's not a good idea is because when you're going through this process and you're trying to get to a conclusion, what you say and how you say it affects your credibility.
Yeah.
And if it finds if it comes out that you have done something and what it says is not what it is, and most typically this issue is not for separation agreements, it's for debts, in quotes, between parents and their married children, right? And because that runs into the issue that I'm not going to explain of whether money put into a matrimonial home is a gift versus a loan. Common issue, and backdating is a common technique and it never works. That I can say that with some certainty. It always comes out and it never helps the case. So generally speaking, that's what I would say. Do not backdate things. It's not smart. I wonder about the question, why would you be doing that? Like who's
Well, if they both agree to, though, what do you do?
I know, but the question is, who are they showing it to that they want to do that? That's really the question.
Yeah.
Right? Okay, fine. Regarding data separation, what's really interesting is that date of separation is a term, but in the Family Law Act, it says valuation date, right? And in the Divorce Act, it says separation, I think. And so there's actually two floating dates. One is the date that you value, and one's the date that you separate for divorce purposes. And usually they align, they're one on top of the other. Can you backdate? Yes, you can. You can agree to backdate that if it's true, right? The Divorce Act also talks about what I don't even know those words. Maybe this is for your Bill, for your band, condonation, right? Connivance, right?
Well, that was back in the day when you had to have grounds for divorce.
Well, I know, but I'm just saying, if you are going to backdate a separation date together for some form of fraud, I think that would fall under.
Oh, I see what you mean.
Right, you got that? Anyway.
So the answer is, it's a bad idea. Most common objections to producing disclosure, irrelevant. Well, lots of people say that, but it's for the court to decide relevancy, and a whole bunch of other answers in here as well. So
I always like it's close enough.
it's close enough. Yeah.
Yeah. It's like
Horseshoes and hand grenades.
I need your
Yes.
bank statement for January of 2022. Yes, but I
Yeah.
gave you the statement for January of 2017. It's close enough,
Well, aren't we a little persnickety?
I am, Bill. I am totally persnickety on that one. I'm a little bit of a stickler.
Let's get back onto the merry-go-round. So there's lots of cases talking about merry-go-round. This isn't just us talking today. Anderson and McWhite in 2010 refers to Justice Quinn in a decision of Gordon Starr in 2007. Bill, I'm just going to steal a little bit of your thunder here, but they go on about the disdain of this merry-go-round of disclosure. And I've seen this in motions court pre-pandemic. Sitting there, the lawyers are arguing, I produced and haven't produced it. The other lawyer, produces a letter with the disclosure that he'd sent to the other counsel's office, and the other lawyer didn't even read the letter. Like it gets that bad. But the essence of this decision is an order is not a suggestion, it's to be complied with. So let's talk about,
they were just suggestions, Ruth.
So let's talk about common objections we hear from our clients. Shmuel, you want to start us off?
I think the one I get at the top is they know. They know.
Yeah.
And I say to them, you're not telling this for their benefit, you're actually telling it for my benefit. And I actually show them at the top of page 2 of the financial statement, it says where you're employed, right? It says name of employer and address. And I'm like, no, I need more than that. What do you do? Tell me what you do. How long have you been doing it for? Right? And And I put that in the financial statement because don't assume they know. And definitely if you're in court, don't assume the judge knows. And in any event, the law doesn't say provide all the stuff that they don't know. You have to provide all the stuff that is relevant. So onus is a very big issue in law, like who has the onus to provide information. And just because you think the other side knows, it's not just about the other side, the other party. There are other people that are involved in this process as well.
Carrie, what are you hearing? Comment, objections from your clients?
What have they given you? And when they give it, I'll give it. We get that quite a bit. I'll show you, I'll show you, it's that I'll show you mine if you show me yours kind of thing. So we get a lot of that pushback, and it's kind of like, well, if you're both going to do that, you're never going to get anywhere. So let's break it down real slow and get us your income tax returns for the last 3 years. Let's start there. Let's start something small and let's work our way up and see if maybe that starts to rebuild that trust. If you want trust and you want to get through this, oh, and you don't want to spend a fortune, start working with us, slowly getting through it. That's a lot of what we hear.
Yeah, I like the one where yeah, the request comes in and my client says, well, it's a joint account. They can just go online and pull the statements down themselves. Why do you want me to photocopy them for your lawyer?
Yeah. We hear that. We hear that. And it's like, well, one of you's got to do it. How about you get the stuff on the house then and you get the stuff on the bank account? We'll just start dividing it up. We'll just start delegating. It makes it a little bit easier for them too.
I had a client who hadn't filed his taxes since the Nixon administration.
Oh, is that my client I have now?
He's like, dude, file your taxes, man.
Yeah.
All right. Let's find out what our audience is thinking. This could be our last poll of the day. What
Burial plots?
common things forgot to be disclosed? And this happens all the time. You could be mid-trial and the other lawyer picked up that my client had some banked holidays. And it was significant. Like they had 6 months banked and it pushed the numbers by 30 grand, and it threw us out of a couple of the offers to settle we had produced. So these things can really come up and surprise you if you don't think about asking your client. If your client doesn't tell you you're mid-trial, now it's going to affect your offers and cost consequences with proceeding. So let's see what our audience is thinking about that. We're going to give everybody a minute to, oh, here we go.
Yeah.
All the above. Yeah. Foreign assets, burial plots, Bitcoin. All right.
I got to tell you, Russ, I did have somebody actually argue that they wanted their spouse's family burial plot. And we really had to understand why they would want to be buried with their spouse's family.
I think they wanted to put a nasty epitaph.
It was an interesting matter. I'm not going to lie. It was. Don't know why you'd want to be buried with your ex, but okay.
Some Costco's and superstores in the US, you can buy coffins. So is the coffin an asset or,
The problem with that though, Russ, you can get coffins at Costco, but you have to buy a 3-pack.
Oh.
And it's it gets expensive.
One for the lawyer.
Is it one of those kiss coffins?
Oh my
Bill, I kind of let the cat out of the bag in this one. Court orders are not suggestions. Talk to us.
Well, I always thought they were, Russ, until today.
Okay.
No wonder. Anyway, Shannon, I don't know if you have that case of D. Sabatino versus D. Sabatino. I think she's going to put it in the chat, but it's 2022 ONSC 334. And this is about adverse inference. Thank you, Shannon. It's a great case because once you've asked a bunch of times and you still don't get the disclosure, the final last resort is what they call adverse inference, where a judge can, make up whatever they want for, within reason, because you haven't disclosed. And I'm just going to make a real quick quote from this case because it's super interesting. In my view, this is a textbook case for adverse inference. The respondent has engaged in a litigation strategy marked by repeated and prolonged failures to comply with disclosure orders and basic disclosure obligations. He has maintained opaqueness over his business affairs, but now wants the court to accept that his, quote, house of cards has crumbled and he has no money. The respondent needs to understand that until and unless he shows his, quote, cards, the court is unlikely to accept his claims about the dramatic downturn in profitability he has suffered. So that's a great case. Adverse inference is your last resort, and it works if you've tried a bunch. You have to try a bunch of times, but then adverse inference kicks in. It's a beautiful thing.
Bill, we got a suggestion for your band name, Fully Disclosed. So
I
if you
love
missed
it.
the beginning, Bill's in a rock
I
band, currently
love
called
it.
Soul
Fully
Custody.
disclosed.
He wants to update the name to make it more modern.
Although it sounds like a big charge with indecent exposure.
Yeah. Shmuel, affidavit of documents. When do we deploy these, or do we? And what are your tips?
Okay.
Indecent disclosure.
I have one for the end, Bill. I actually came up with one.
Want to keep it
Okay.
PG.
So Rule 13 or Form 13A, the disclosure certificate, is actually a relatively recent addition to the family law within the last 10 years, something to that effect, or actually maybe 12 years. In regular civil litigation, there's something called an affidavit of documents, which is still included in the family law rules. I'm going to show it to you because I'm not going to show you an actual one. I'm just going to show you the rule.
I ain't never done one of those. Shmuel.
Well, I'll tell you why we don't hear about it often in a second. But so
But they do exist.
Rule 19.
I should do one.
We should all do one. Just
Now you got me thinking.
like, do your will and do your affidavit of documents. Rule 19 talks about document disclosure, so it's a little bit confusing, right? Because Rule 13 talks about financial disclosure. So what are we talking about here? And so Rule 19.1 says, subject to 1.1, which we'll get to in a second, every party within 10 days after a party's request gives the other party an affidavit listing every document that is relevant to the case, and the and is important, so don't forget relevance, and in the party's control or available on request. So the point of Rule 19 is to avoid being surprised at trial. Ha ha ha! I have this document. Okay, and again, it's common in civil litigation, and it's not common in family law. And the reason for that is that if you ask the other party for an affidavit of documents, they are going to ask you for an affidavit of documents. And it's like, what they called MAD during the Cold War, which is mutually assured destruction, right? Nobody wants to ask because they don't want to do the work on their end, rightly so. Importantly, for our purposes today, the exception over here at 1.1 talks about that the rule does not apply in respect to documents required to be served under Rule 13. Which, by the way, is a good question of, like, do we read the word required as like the basics as I started off with today, or does it include all of the other relevant stuff? Usually, in my experience, a Rule 19 request is usually centered around non-financial issues, usually parenting issues, and the common things that people are looking for, in addition to, for example, school report cards or other school-related stuff regarding the children, or other kind of reports related to the children, are text messages. What text messages are you going to hold up against me at trial, right? And so that's usually what I find. The other issue is, and this has become a huge issue, I just want to say this out loud, that what emails of mine do you have? A lot of people are dealing with data breach issues. There was a case just last week dealing with this. What do you have of mine in your possession? I want to know. And Rule 19 is the way to do it. So we don't hear about it a lot in the context of financial disclosure, because it's usually covered under Rule 13.
All right. So good to hear. careful what you're asked for is what I hear you saying.
Yes.
But you know, some people as a litigation strategy try to wear it the other side and run them out of finances. So you want to be mindful of that. Carrie, hot tubbing and experts. This sounds exciting, right? Hot tubbing? This
You
is
know
language
what?
of the court, not us.
I'm always down for a good hot tub, but I'm feeling like this is not what you're about to talk about.
Why do we have experts hot tub?
I'm gonna be
Basically,
honest.
what we do, we have two expert reports and they differ. So your case management judge will say, tell them to go get hot tubbing, which basically is have them talk about why their reports are different, provide a summary. I actually went through this recently. They got it down to 5 issues, which was really helpful in terms of narrowing the assumptions and some of the numbers that they're coming up with. But we were still $1 million apart. So it might have shortened their evidence by 5 days, but there's still a dispute that we need to resolve, and we're working through it. But it was kind of interesting just to find how different experts can come up with different assumptions and different results when dealing with the same business asset or same approach. Shmuel, have you come across this hot tubbing requirement very often?
Yeah, so let's take a step back for a second before we talk about the experts hot tubbing, to talk about experts for a second. It always shocks me. Like, I still am shocked when people go to trial. Okay, not many people go to trial, but where they are fighting over what the experts are fighting over. Like, think about the loss of control you have over your life right there. And if your expert is wrong, you have to pay the costs, not the expert. And so the concept of hot tubbing is to help the court, really, which is, hey, you two are supposed to be neutral experts. They have to sign a form, a court form, the 20.1, I think, where it says that we have a duty to the court. And the court's basically saying, by the way, and one more thing, this concept of hot tubbing also came from civil. It's not a family law term, it's a civil procedure.
I found out where it came from, Shmuel.
Yes.
The term, it's from the 70s from Australia.
No kidding.
There's a Canadian lawyer article if you Google it. Anyway, sorry. It had to be Australia.
Go Australians. But really the court is saying, hey, experts, narrow the issues that you guys are talking about. You're the experts. You know exactly. I want to know exactly where you're apart, and me, judge, will have to make a decision. There was a case, the case that I was thinking about regarding the texts or the emails that were surreptitiously taken. That same case, and I'll throw it in shortly after I stop talking, talks about competing expert reports where the valuation method was disagreed on, which is like question number 1 that every expert has to deal with on valuing a business is, what's the methodology? And they disagreed on that. And okay, but fine, the judge was able to say, okay, I understand as a line item, that's what the experts are disagreeing on, and I will make a decision as between the two of them. And they did, and the judge did so. So that's the concept of hot tubbing, which I recommend, if only to mitigate your own risks, because why are you going to trial on somebody else's opinion? It's so crazy.
Yeah. Well, of course they're going to direct it too, because it's going to make the trial judge's job a lot easier.
Sure.
To get a summary from the two experts as opposed to hearing the evidence and trying to decipher the differences. Okay, let's get into the nasty. So, Bill, I'm going to flip the first two to you. Started talking about adverse inference. Motions and disclosure. What do we need to know?
Well, you've got to, disclosure motions obviously are a last resort, or the second last resort, I guess. Try to avoid them. I've been on a few. There's sometimes I had a case where they were fighting over the value of a fast food franchise that one of the parties owned. And weirdly, it was the financial expert on the other side who demanded, and it wasn't Carrie, she would never do this, demanded that the client allow him, not the client, but allow the expert to call head office of the fast food company was a big one. Wasn't McDonald's, but it was right up there. The expert wanted consent to call the company and discuss in detail how much the franchises were worth, who's buying them, this kind of stuff. And the judge said, you know what, that's beyond. Just use the word beyond. And they would never order that. So, but they tried. So when you do these disclosure motions, I mean, people throw stuff against the wall to see if it sticks, and sometimes you have to do it, and you're not going to get everything you want.
Yeah. In questioning, sometimes I question the value of questioning. I think counsel employ it as a delay tactic, or written questioning. You're not getting the same reaction from the witness. But Shmuel, what do you think of questioning? Or examinations for discovery is what we used to call it, but
right. So questioning was not meant. What is questioning? It means you are cross-examining, because one party gets to ask the questions and the other party has to answer the questions. And it's under oath, and it's recorded, and it's transcribed, and then those answers can be used for trial. And the rules actually don't. When the family law rules were created, they didn't want questioning to be done so often, and we throw it in now. After a case conference, we agree to go to questioning, but you really have to ask yourself, why are you going to questioning, and what kind of questions are you asking that you need answers to? Do you need general questions of like, what do you do for a living kind of questions? Well, can you get that in writing? Like, is there a way to do that that's not doing the whole questioning thing? And then the other types of questions you're looking for are admissions. So if you want to say, hey, you don't, isn't it true that you have cash income or income that you do not report on your 2022 income tax return, right? And that's a question mark, and it's a yes or no question, right? And if the party says no, well, you've just boxed them in. Okay, they just said no, that in 2022 they did not. And then you can start asking for disclosure about 2022. And if you can prove $1 of cash non-reported income, then your questioning was worthwhile, right? But you got to think about, why are you doing this? There is a cost to the delay, obviously, but also to the preparation, to the attendance, to the transcripts. Transcripts are not cheap anymore. They're all digital, so they raise the prices because they can't have multiple orders anymore. And then there's the follow-up. It's actually it's an expensive process, and it should be used smartly, not just as a matter of course.
My experience with case management judges, they show a lot of deference to the request, right? They'll say, well, it's a he said, she said. I can't decide. Go do your questioning.
You can always get
easier to get than I would expect. And the only way you can scale it back and kind of control the cost is have it done in writing. Then you're not doing a physical attendance at an examiner's office and all the rest of it. But
I find that one of the best tools of limiting is actually limiting time, so that it really focuses the person asking the questions as to what's really important to ask.
Like an hour, 3 hours?
I mean, most reporters require a minimum of 3 hours, so that's usually the.
Okay. All right, striking pleadings, Bill. Another tool in the nasty toolbox.
It is the last resort. It's rare. Basically, what you're doing is you're setting up an uncontested trial if you strike someone's pleadings. So again, it's very rare to get. The other person has to behave so badly for so long. I've never done it, but I've read the case law, and it's.
I had it done, and then the trial judge still wanted to hear the other parent's evidence.
Exactly.
Which kind of defeated the purpose a little bit, because there wasn't really any merit to their claims. But the next step is, I think contempt of court is beyond striking pleadings.
Yeah, well, that's
end up with somebody incarcerated.
Well, that's the thing. I've had a
me?
contempt brought against my client. It didn't go anywhere because you have to prove it beyond a reasonable doubt. It's like a criminal trial, and and they fine the person or put them in jail. It's very, like, if you overhold the kids for a weekend and don't give them back, you don't move for contempt. But client will want to.
No, but in terms of disclosure, if you have a litigant, and we all know these people who will stop at nothing, really contempt might be the only remedy, especially if they're not appearing for court or showing up.
It's absolutely, but it's a last resort, and it's very rare to get.
Yeah, it is rare, but I've seen it happen, and actually require is to do it right. You should have viva voce evidence and a proper process. Lots of judges, or some judges, would just make a finding from the bench, which I don't think is the correct way to approach it. Okay, so let's bring this train into the station. We're going to do tips and tricks. Shannon's going to come back on in a few minutes. We're going to do some Q&A and get everybody on their way. It was an ambitious agenda, but we got through a lot of it. Tips and tricks. Carrie.
Can you talk, Carrie?
We have a few hundred people waiting to hear your tips and tricks.
Carrie, can you talk about your woodshed?
Yeah, I just still take you out to the woodshed and be until you give me the disclosure that I need. There's that. But honestly, the best tip that I can give to people is get help. So if you have an accountant, get your accountant to get your income tax returns and your notice of assessments, your financial statements, whatever you need on that stuff. Use your bank to get your bank statements. If you're going, I don't know what to do, go to your bank and say, hey, help me with this. Use your financial advisor if you have one to help you gather some of this disclosure. They're the best people out there. They know your stuff intimately, and they're going to get you exactly what you need. My office provides a list, a checklist, like you just check it off. Yes, I got it, need it, got it. Kind of like baseball cards. And you can take that into your accountant, your financial advisor, whoever you need to, and go, I need all of this. How do I get all of this? Or we'll do it for you. That's the other side of it. So just get the help.
The other trick you have, I've seen you run credit reports, and then that shows up accounts that haven't been disclosed because it's applying for credit.
Yeah, credit reports are great that way. The other thing that for most people is, I hear this all the time, is they said this, they said that, they're not going to disclose this, they're not going to do that. My thing to everybody is everybody's going to say whatever they want during this process. Everybody is highly emotional. Everybody is on pins and needles, and money is fear-based. We all need it to survive. We all need it to move forward. And so, you know what, everybody can say whatever they want. It doesn't mean you agree to it. It doesn't mean that's your result. You know, just take it one step at a time and make sure that you're having good conversations and getting the answers that you need. Ask your questions.
Shmuel, tips and tricks?
So, I mean, there are two levels of disclosure. There's what you have to provide, which is the Rule 13, and then there's the additional that you're asked to provide on top of that. So for the asked to provide, I'm with Carrie, get help. I would refer people to my website under the apps menu. There are a lot of different pieces of helpful things to work with. That's on the stuff that you should be providing. On the stuff that you're going to be asked, ask your lawyer. And if you're the lawyer, think about, if you were the lawyer for the other party, what would you be asking of your own client? And make that checklist for the client and say, you're going to be asked for this information. So start working on it now before it's even asked. And we may even provide it before it's even asked. And if we provide it before it's even asked, we may even be able to get away with providing a little bit less, because they're going to be say, oh, they're being trustworthy. They're providing information that I need. I was going to ask for it anyway, and they didn't, and they provided it. So that element of trust is going to always come back up. And if you can get ahead of that game by predicting what documents are going to be asked of you and then providing them, or at least gathering them so that when it is asked, you could just provide it and not be chased for it, you're going to go a long way in finishing and getting through this process.
Yeah, great tip. And Shannon, our host, is magically back. You think you can squeeze a couple questions in addition to what we've answered, Shannon?
Yeah, if everyone's okay with that and has time. We had lots coming in. We won't be able to cover them all, but we'll go through a few if that's okay. So the first question I have here is, how do you deal with vexatious disclosure requests when you are not in court in pre-negotiation stage?
Right. Shmuel or Carrie, what do you think? I'll tell you what I would do if, sorry, did you want to go ahead, Carrie?
No, go ahead, Russ.
What I would do I would state why I think the disclosure is not relevant. And if necessary, we'll review the issue with the case management judge if it becomes appropriate. And then they can, if they can't explain the relevance to me, I don't think they'll be able to explain it to a judge. And so you're actually responding to the request. You're just not producing it. What other questions you got, Shannon? Oh, sorry, Shmuel.
I was going to agree with that. I mean, if you're vexatious before court, that kind of sounds like you're going to be going to court.
Right.
So I think that your approach is right on.
Yeah.
Great, thank you. Do the financial disclosure rules apply to marriage contracts as well? For example, prenups or postnups?
I'm gonna say, yeah, if you want something to be taken into consideration inside of prenuptial agreement or a relationship agreement, you're gonna have to actually disclose what it is you want protected. You can't just say, well, I want my business protected, but I'm not gonna give you any information about it. That doesn't mean anything. So how many businesses? Is it one business? Is it 10 businesses? Or like, what are we talking about? I think you have to be upfront and honest about what it is you actually want protected from the marriage.
Well, the purpose of the disclosure is so people can make informed decisions.
Yeah.
And if you're not disclosing it, you can't make an informed decision. The agreement's probably going to be set aside by the court. I see Bill nodding his head. Shmuel,
No, I agree, Russ, and it actually says right in the Family Law Act, I believe, that one of the grounds for setting aside a domestic contract is the failure to disclose a significant asset.
Yeah.
Yeah, so I'm gonna add two quick things because this is a really important question, actually. So the case law, because people have fought over this very issue about the extent of disclosure, is very clear that you do not need to complete a Form 13.1. If you have a sheet with a list with assets and the values, then that is good enough. The funny thing is that we lawyers, we make the best agreements. It's the other lawyers that make bad agreements that we seek to set aside. You think about that. And every agreement is like a time bomb because somebody may be in the future want to set it aside. And so there's a risk analysis that you have to have. Regarding that risk, it increases exponentially for a postnup, because that's the question I'm looking here. At postnup, the rights in law have already vested, right? And they're already in play. So if you're going to do a postnup, you better actually do disclosure that you, as if you are having a separation, and in a sense you are, if you're having a postnup. And so you should have a date of marriage column and you should have a current value so you can actually do the equalization because that is relevant today, right? For this agreement.
Yeah, we can answer these all day. Shannon, one more. Come on, we're having fun here.
All right. I think this one will be a quicker one. What is the page limit for this affidavit of documents that was discussed?
I think it would be unlimited, but I don't know.
I'll say, I mean, that was my piece. It is unlimited. There is a format to affidavits of documents. There's a schedule A, B, and C. There's a question about whether you have documents that are in your control that are protected by privilege. And so, no, there is no page limit for affidavits of documents.
Thank you, Shmuel. So we'll wrap up there. Thank you, everyone, for sending in your questions. Thank you so much again to our speakers, Carrie, Bill, and Shmuel for joining us today for this presentation. Very insightful, and we also just appreciate everyone's participation today. So we'll wrap up there. I know people were asking about links that were mentioned throughout the presentation. Some of them were in the chat, but we'll also send an email tomorrow as a follow-up with all of those links in there as well, so you can look at them on your own time. So that's everything for today. Thanks so much again, everyone, and we hope you have a great day.